Well, hello, my friends. Welcome to me, your host, Christian Watson. My friends, the Ketanji Brown Jackson hearings have been all the rage recently in the media. Indeed, as of the time I'm recording this video, and it's certain to have changed by the time this gets posted, the Ketanji Brown Jackson hearings have concluded their third day. Although, having watched the hearings closely from the first day to now the third day, I think I have heard much of what I need to hear. Indeed, my friends, really, it doesn't take me or anyone else very long before they can form a conclusion, and you don't need every single ounce of information to form a conclusion. You simply need enough information, and I've got enough information. And on the basis of the data that I have about Ketanji Brown Jackson's sentiments, I am wholly unconvinced that she, as a matter of her jurisprudence and her approach to philosophy, is fit to sit on the high court. Let me say this, she's a very smart woman. She's a very accomplished woman. She's obviously a very rhetorically intelligent woman. Her qualifications in terms of her background and things of that sort are obviously not in question. What's in question here, however, is her conceptual understanding and how her conceptual understanding or lack thereof might play into some of the current issues happening in the legal system right now. So I have two fundamental objections to Jackson being nominated as Supreme Court Justice. Number one is that Jackson consistently conflates her methodology with her philosophy. Now, my friends, a methodology is not a philosophy. Rather, a methodology is only a tool that is only as good as what it works on. What do I mean? So, for example, to explain what I mean, let's analyze the nature of a syllogism. So a syllogism is basically a logically valid statement with premises, a conclusion. It's an argument. But a syllogism is only as valuable or valued. It's only as true as what's in its premises. So if I say all dogs are mortals, Jack is a dog, therefore Jack is immortal, that is a perfectly valid syllogism because the conclusion conforms quite neatly to the premises. It follows through the argument. If all dogs are mortal, then it would follow that if Jack's a dog, he's definitely immortal because he's a dog. It makes sense. But that syllogism doesn't actually tell me if, in fact, all dogs are mortal or if, in fact, Jack's a dog. If one fact in that syllogism is incorrect, the entire argument may be valid in a logical sense, but it is incorrect in a factual sense. Now, here's how this connects to Jackson. Your methodology is only as good as the principles you have to guide it. The philosopher Lord Keynes said that conscience is the guide for our principles of action. It is not contained in it. It is above it and over it. But for Jackson, conscience or what have you, philosophy or what have you, exist inside of the method, and she doesn't really consider it outside of the method, or at least this is how she presents her beliefs in these hearings. I will show you this clip right here to certify this point.
So respectfully, Senator, I do have a philosophy. The philosophy is my methodology. It is a philosophy that I have developed from practice. Unlike some judges who come to appellate work from academia and who have some overarching theory of the law, I approach cases from experience, from practice, and consistent with my constitutional obligations.
So, my friends, with all this in mind, it is concerning that Jackson uncritically clings to methodology as her philosophy. She has said this exact thing. She has said that her methodology is indeed her philosophy. Without a holistic worldview upon which she approaches legal or moral matters, her thinking is entirely conditional. And my friends, if your thinking is entirely conditional, you cannot see universals. Now, help me with this. The American legal system is predicated upon natural law. It's predicated upon universality of certain moral principles. But if you're constantly using a methodology and not actually thinking about the broader implications of that methodology, then how in the world can you satisfy the foundational principles of the American legal and constitutional system? You cannot. It is virtually impossible to do so. But Jackson is thinking is compartmentalized to action as opposed to reflection, if her words are to be believed. Now, I am fully willing to admit that Jackson is not fully being honest with the entirety of her philosophy. She does indeed have one. She clerked for Justice Stephen Breyer. Perhaps she does share some of his philosophy about the Constitution. But she understands, perhaps, that if she were to say that, it would actually be pretty toxic to her nomination because, again, judicial philosophies are a pretty hot flashpoint in political conversations. But I can only go off of what I can see and what I can deduce through reason. And so far, Jackson has said repeatedly that she does not have a philosophy. She has a methodology which she thinks is her philosophy, and that is an erroneous statement for the reasons I just stated. And it's concerning. If you are in the local and you can't see the universal, you will always miss the broader moral significance of your actions, and that can lead you to some very dark paths. Now, my second objection, my friends, is perhaps downstream of this servility to method, to action, as opposed to reflection. And the servility to method and action is reflected, I think, in Jackson's rulings about child pornography. I hate talking about this topic, but I have to, because it's been one of the biggest things about her hearing. So Jackson has notoriously sentenced child pornography offenders to sentences that are lower than the guidelines suggested by the actual guidelines and by the prosecutors. Now she justifies this approach with two justifications. A, Congress made me do it, and B, disparities are bad and a judge has to fix disparities. Well, to the first point, we have to understand that Jackson is arguing that Congress basically influenced her decision-making, which is fine. Congress sets rules, they set laws. By their nature, they're going to influence your decision-making. But here's the point. In what world does a guideline, because Jackson's is talking about guidelines here for sentencing, in what world does a guideline substitute for conscientious judgment? Once again, Lord Kane said that the conscience is the director of our actions. It's not indicated in the actions, it's rather the director of our actions. He said, actually, I'll quote from him right now, he said, we may observe in the next place what will be afterward explained, that conscience or the moral sense. So not just any old conscience, but the moral sense is none of our principles of action, what we do, but their guide and director. So if Kames is correct, and I sincerely believe he is, then conscience, which is attuned to proper principles, our moral sense, should guide any ethical decision. Arguably, all legal decisions ultimately concern ethics as well, because obviously they have to do with the legal system and they have to do with other people. Anything that concerns other people will have ethical implications. But even if one rejects the authority of conscience, as I have so argued in this video, Kames' general statement is correct. Actions cannot be committed for the sake of themselves, or they risk becoming irrational and incoherent. Lest we risk contradiction, actions ought to have a higher moral goal or a higher moral thought guiding them. In either case, whether conscience is the dictator or not, Jackson has either not thought of or does not care to engage with ethical niceties, and thus misses out on a very crucial aspect of legal and moral decision-making. Now we have to talk about the disparities that she mentions. My friends, if I'm going to look at a case for its merits, I'm not going to look at it solely in relation to other cases. Let us say, because she argues that one of the reasons why she sentenced some offenders of child pornography to lesser sentences is because there were disparities that needed to be addressed. Well, first of all, a disparity is not inherently evil. There's a disparity in everything in life. When there's a race, there's a disparity in who wins. When you look at society, there's a disparity in almost everything, in terms of looks, in terms of intelligence, in terms of everything. Disparities literally exist. They are built and baked into the nature of this world. There is no world in which disparities do not exist that is not an absolute nightmare. And even in those nightmarish communist collectivist societies, disparities most certainly exist between those who are confined to the bottom by force and those who use force from the top for their malevolent purposes. So don't you give me this talk about how disparities, well, the disparity is bad. Disparities are a necessary fact of life that we have to reckon with. And the problem with people like Jackson, and the problem with people who don't understand this, is that they think that they can bring their idea of heaven onto earth, as Vogel warned against, and they can conform everything, the laws of reality, to their own ideas. And that's not how things work. This blatant disrespect for how things are, for the nature of things, is what is going to end up destroying any attempt for anyone in any system, much less a legal system, to have any kind of moral guide. When you popularize a certain kind of thought, as Scalia did with originalism, it goes downstream, which is one of the reasons why I think Jackson is actually temperamentally conservative, because she has constantly said that the Constitution is not a living document. But on the other hand, she says stuff like this. It's not enough to be temperamentally conservative. You have to go all the way, and you have to embrace foundations, and you have to understand foundations, and you have to understand deeper theory before you can be valid as a judge or any kind of thinker. But anyway, let's look at this. There's an academic interest in considering disparities in legal decision making. But in the context of sentencing, I'm not convinced that an individual court case should be a tool to correct general disparities. If I can tell that Mike murdered someone, but Mike happens to be a black trans man, would it be prudent for me to not sentence Mike to a harsher sentence because black trans men are allegedly have a higher disparity in the system? Of course not, because that would be using Mike's identity, not his actions, to justify or weigh his actions. And not only is that incoherent, that's also unjust. Justice has nothing to do with how you look and everything to do with what you do, how you treat your fellow man. Your identity cannot be just or unjust, but you as an individual can be just or unjust, and thus justice is individual quality. But the moment justice becomes subsumed in these broad collective ideas is the moment justice evaporates. So not only do I find Jackson's lack of philosophy and her reliance on principles of action and isolation disheartening, I also find her reliance on Congress's guidelines as a means for eschew responsibility, and Jackson's reliance on the inherent so-called evil of disparities. I find both of those things concerning. I find them philosophically dubious, and they are unbecoming of someone who wants to occupy the highest court in the land, which most certainly gets its power, is simply downstream of the adoption of a natural law legal system, which unfortunately is so tied up right now in common law and has gotten so far away from philosophy. The American legal system has gotten so far away from philosophy that it is ridiculous and it is disappointing. It is shameful. Jackson's not unqualified. Jackson may not even be a bad person. This is not about her personhood. This is about her principles, and they are rank and have no place, at least in these instances, have no place in the Supreme Court. Think on it, my friends. I love you guys so much. And if you love me, patreon.com/officialcwatson or PayPal, officialcwatson@gmail.com. Please join my Discord, which is comment section down below, or please like, share, and subscribe to this channel, this video. I love you guys so much, and please stay fancy. Bye, guys.